Milord market, Milord. Truth case. It was fixed yesterday, Milord, but non-district. So my period day after tomorrow it may come, Milord.
What is the matter?
Settlement of market.
Huh?
Settlement of market, Milord.
Make it a mention before the senior bench. No. Senior bench. Bench 4. My Lord Justice Borua. Yes, Mr. Chaudhary. You were supposed to file an affidavit.
We have received it.
Okay.
Hello,
Mr.
we also need some time to file reply to us.
Mr. RKD Chaudhary, learned Deputy Solicitor DY SGI, submits that in terms of the submits that an additional affidavit has been filed by the respondents represented by him today. Is being filed by the respondents represented by him today. Full stop. Mr. SP Sharma, learned counsel for the petitioner, submits that he be granted 2 weeks' time.
3 weeks time.
3 weeks' time. 3 weeks' time to file a response thereto, if so advised. Full stop. Registry accordingly to list these matters again after 3 weeks on a date to be fixed by it.
But I have an interim order. Man.
Interim order passed earlier to continue till the next date of listing. Or OED. Mr. R. Dhor, learned standing counsel, enforcement directorate is present for the.
But can there be a fixed date? 60.
Yes.
That is your lordship. My lord, in item number 16,
Hmm.
we're supposed to file an affidavit in reply,
Hmm.
but yesterday we could not file it because the standing counsel NHI was not,
You are for the petitioner.
and for the petitioner.
In item 17, we have already filed yesterday.
Like,
There is an interim order operating.
yes,
That's something with regard to some falling of a grider.
yes.
Mr. A. Dhar, learned counsel appearing for the petitioner. It to me, WPC 3647-2025 with my submits that he be granted a week's time to file a response to the affidavit filed by the respondents. Prayer accepted. Registry to list this matter again after a week, along with WPC number 4833-2025. Also 4833-2025 would like Mr. A. Chetri, learned counsel for the petitioner, submits that a reply on behalf of the petitioner has already been filed. Full stop. Accordingly, a registry to list this matter after a week, along with WPC number 3647-2025.
Interim order.
Interim orders operating stand extended till the next date of listing. Beleg ke maidiva.
Obliged.
Obliged, lordship.
Yes, Ms. Alam. Means I can't take this.
Already order, my lord, to us.
Okay. Registry to list this matter before any other bench without me.
Also, I beg to mention item 8, your lordship. Here the working council is not available. Second consent from the other.
Nothing is there. We have heard the matter. Only an order is to be passed today. We'll pass the order. Or you ask her if something to add, then you tell me. Okay. Already heard. I've heard her at length.
Yes, sir.
Then I was not sitting. That's why. We'll pass the orders. Don't worry. Yes.
Concern of the other side, my lord, I beg to mention item number 14 and 15. My lord. For the petitioner for item number 15, I've taken consent for the
Why?
conducting counsel for item number 15, my lord.
Who is it?
Our Muzumdar, my lord. The
Oh, you are there. You argue. Mr. Monto is there. Take the Mr. Monto will argue his matter. This is that Home Guards. No, GP secretary promotion. Show me that there is a rule that which permits or something which permits this thing, because their categorical stand is that this is not permissible as on date. Just show me that, we'll finish it up. Why keep this matters pending?
So petitioner are trying to engage some other council, so that's why.
It's more than, I think, a long time. The arguing council is not that side, come this side. So you should have taken steps by now.
Pray for 1 week, my lord. 1 week.
You are there in the matter, no?
I'm not there, my lord. We have not filed.
So you have been engaged. You are
B does, my lord.
DDAS, learned,
Yes. B does.
BDAS, learned council, appearing for the petitioners in WPC number 3725/2024 submits that he has been newly engaged in the matter and prays that the matter be taken up after a week to enable him to make his submissions in the matter. Full stop. In view of the above, a registry to list this matter again on 18/11/2025 along with 18/11/2025 Mr. H.K. Mount learned counsel appearing for the petitioners in WPC number 3601/2024 is present. Yes, madam.
On behalf of senior advocate M.K. Suri.
Which are the cases?
Yes, item number 22 to 24,
22 to 24 and 25 also.
25 also.
Any other? Any other matter? Item number 22 to 25. A prayer is made on behalf of Mr. M.K. Chaudhary, learned senior counsel, for an adjournment in the matter on the ground that he is in bereavement. Prayer accepted. A registry to list this matters again after 2 weeks.
6.
2 weeks on a date to be fixed by.
Here, the issued order of major penalty of removal challenged, my lord.
Yes.
Major penalty of removal, my lord. Challenge in this. My lord. Here what happened, my lord? This is third round of litigation, my lord. First round of litigation, my lord. First, my lord. Suspended. No
With
decision.
regard to the departmental proceeding, this is the first case.
First case, my lord.
Those are ancillary
And
matters.
then, my lord, still even after 2 years when nothing was done from the disciplinary authority, my lord, then I preferred second round of writ petition. The second round of writ petition, my lord,
What was that for?
taken up, my lord. Then, my lord, the learned
Government advocate
apprised, my
informed
lord,
the court,
before
apprised the court that the petitioner is already removed.
removed. Now that removal order, my lord.
What
Here,
is
my
the
lord,
charge against you?
my lord,
Charge.
charge. Charge, my lord, kindly see the show cause notice page 36, my lord. You are hereby required to show cause under Rule 9 of the Assam Services 1964 read with Article 311 of the Constitution of India. Why any of the penalties prescribed in Rule 7 of the aforesaid rules should not be inflicted on you on the following charges based on the statement of allegations attached herewith. May I read, my lord? Here, my lord, attached herewith that while you were, number one, my lord, that while you were serving as
So there was an allegation of misappropriation.
misappropriation, my lord.
Okay.
There was an allegation. And then, my lord, before I go in, my lord, Then the vital point is that, my lord, this notice, my lord, was served to me after getting the notice from this honorable court, my lord. The writ petition, my lord.
Is
This
there any
notice
bar?
was-
Is there any bar in that?
No bar.
Then fine.
Just, my lord.
Concentrate on that.
And then, my lord, the point is here, my lord, this notice, my lord, asking the petitioner as to why no disciplinary proceeding shall not be initiated is not given. But the punishment, my lord, what
Where is the requirement that before issuance of a show cause, a preliminary show cause is to be given? Is there any provision in law? In the rules? It's not there.
then, my lord,
This is a rule 9 show cause.
focus, my lord.
So, okay, fine. What, any infirmity in this show cause?
Focus, my lord, directly they have asked me to give reply, my lord, as to why the, my lord, reply on punishment that is already decided, my lord. They had no opportunity of giving me the reply, my lord, as to why the disciplinary.
Where is that? Where is that what you are trying to highlight, Mr. Mullah?
My lord.
Where is that in this
Mm.
notice?
So, my lord, this is the.
No,
notice.
where is that prescription stipulation that you are making a submission? That the punishment is already incorporated herein. Where is that?
Punishment, my lord, in the impugned order.
Oh, in the show cause, they have not done anything.
Focus, my lord. Table, sir. Yes, my lord, in the show cause, this is not done, but in the final order, my lord,
They'll have to do it. Okay, fine. Now, next, what is then you submitted a reply. Mr. Mullah, you are arguing a disciplinary proceeding. Kindly take this court through the stages.
lordship will understand.
I'll not understand.
Lordship-
If you don't make me understand, I'm not going to understand.
Then, my
It's
lord,
your duty.
my case
Your
is,
client has appointed you to make this court understand. Make me understand.
my lord, here, my lord, my case is the charge sheet containing list of documents and witnesses,
Hmm.
my lord, should be served.
Hmm.
No charge sheet, my lord, containing the list of.
Did you submit a reply? Show cause written statement?
Written statement, my
Where?
lord,
Where?
I could not annex here because, my lord, Xerox copy, that was not, my lord, acknowledgement was not taken, my lord,
Okay, you submitted a show cause reply.
my lord, and record revealed, my lord.
Have you made a statement to that effect?
Yes, my lord. Paragraph 9, my lord, page 11.
Did you raise any contention therein that you were not served, you were handicapped in preparing a show cause notice, a written statement because of absence of documents? Have you asked for inspection of the documents, etc.?
Yes, my lord, here in paragraph, my lord, 14, page 15,
Huh.
the petitioner states that the disciplinary authority, without conducting departmental proceeding in a.
That is subsequent. That is subsequent. Department inquiry will come subsequent. Now we are in the written statement stage. Did you ask for the documents? That what are the documents you are relying upon? Tell me. Or give me copies or give me inspection. Did you raise any such points?
Not for inspection, my lord.
Where?
Here, my lord, paragraph 14, my lord.
Paragraph 14. Okay.
Officer also is not known to me, my lord. I appeared in the hearing, my lord, but none of the officers were, my lord, present.
Okay. After you submitted the reply, what happened?
Then, my lord, I was waiting for the finality, my lord. Then nothing was done. Then,
No
my lord,
departmental inquiry held.
no, my lord.
No departmental inquiry. Where have you said that no
Then
department?
after submitting this written statement with documents, my lord, then my lord, I preferred second round of litigation. writ
Okay, but
petition.
now that you were never called by the inquiry officer.
No, my lord.
Where have you stated that?
Inquiry officer did not call me to that effect exactly, my lord.
Then
Yes, my
did you
lord.
participate in the inquiry?
I appeared, my lord.
You appeared.
I appeared.
Okay.
In paragraph 11, my lord.
Paragraph?
Paragraph 11, my lord.
Hmm.
That the petitioner stated that the disciplinary authority immediately after receiving application along with the court's order served a notice to the petitioner.
Okay.
But this is the
Where is the inquiry report?
inquiry report, my lord. I was not furnished, but in the affidavit, in their affidavit, my lord, they have annexed here one page of inquiry, my lord. That is initial. Prior
Where
to-
is that?
prior to suspension, my lord.
Where is that?
My lord, affidavit filed by respondent number 6. And my lord, annexer one running page. Here 4, my lord. Running page I have not seen, sorry, my lord. Affidavit filed by respondent number 6.
Okay, then they pass the final order.
Final
Where is
order.
the final order?
Final order in my writ petition, my lord.
48.
My lord, please.
Okay. Yes, Mr. Moore. Where is the file? Documents. Where is the inquiry proceedings? Why? Why? How have you said in your written statement? How many witnesses were examined? Was he allowed to cross-examine those witnesses? Where is your affidavit to that effect? Where is your statements in the affidavit? Impugn order I have seen, yes. What is there? That show me. Show me. Show me where he has admitted that, how he has admitted that. That is the end of the matter if he has admitted. Tomorrow. Tomorrow. No, 14 matter. Mr. Kumar, you should have.
Friday, Your Lordship.
This is from Guwahati only.
2013 matter, Your Lordship.
Oh, I don't know. You have filed affidavits. The records are not there.
On Friday, Your Lordship.
Thursday. Okay, that finding in the impugn order that you had accepted, you had admitted to the thing. Have you counted that in your writ petition? That you misappropriated, there is a line, as Mr. Kumar has pointed out, page 49, the penultimate paragraph. The delinquent officer during inquiry had admitted that most of fund is meant for IAY were misappropriated by him. Have you dealt with that here in your writ petition? That finding.
Reply. I have given.
In your reply you have, where is that? No, in your writ petition, why have you not dealt with that matter? That is a false finding, something.
Some explanation is given in the writ petition.
No, with regard to that finding, what is there?
Silent. He's silent.
In your reply, have you said something, Mr. Mullah? What have you said?
Most of my contestants, my lord, admitted by the respondent authorities, my lord.
Let us admit everything. I only want whether you admitted before the inquiry officer.
I have said, my lord, due to some raw materials, my lord.
Where is that?
When
Where do I get
damaged
it? Where do I get it?
Due to.
Where do I get it? That statement of yours, where do I get it? Okay. Material. Mr. Kumar, get the file. Okay. Mr. Kumar is insisting, so Friday.
My lord.
But I'll want that thing that day. His statement before the inquiry officer. If that is not there, then I'll have to interfere with everything because this is in gross violation of everything. Your only saving clause would be his acceptance of the charge in the inquiry. Thereafter, no inquiry is required. So, Mullah, everything now hangs on that. Okay, fine. Friday.
All right.
At the Learned Counsel for the parties. So, during the course of the hearing, the records of the inquiry is felt necessitated to be perused. So, accordingly, Mr. K. Kumar, Learned Standing Counsel, Panchayat and Rural Development, Additional Advocate General appearing for the respondents, has submitted that the records of the inquiry would be produced on Friday, date to DDA, 14/11/2025. Accordingly, registry to list this matter again on 14/11/2025 for further hearing. Yes, Mr. You are for the petitioner. And Mr. Bora, you are appearing for? Mr. Chavan, you are for respondent number 5. Respondent Durga, sorry. And Mr. Bora? 6. Okay. Now, before we go into the thing, what is the situation today?
All working, my lord.
Huh? All are working.
All working. Was 13, 14 years.
Both of you are working. And the petitioner is also working
There was an interim order and
in
pursuant.
persons of that. We need not go much further, much back beyond the orders passed by this court, coordinate bench of this court in the last round of litigation. Therein, there was a stipulation that if he is to be removed, then give him a notice. Have you given him that notice?
That notice is not.
Then the order of this court is violated.
Otherwise, my lord, otherwise. Now, this. Round of litigation.
We got it. That order was passed sometime in
In the year 2014.
14. So it is around 9 years.
Thereafter. Hence there.
In
Always
Silchar.
NPS.
When all are ready, Mia Bibi Rajiv, what should this Kaji come in? We are going to not, we are going to allow him that removal, we are going to set aside. say that the department has accommodated all the three. So let that situation continue.
Thought instructs.
All.
Regarding my.
That is not the leak.
You want to establish that it is only you who are there. You tell me, we'll go into it. How many posts were advertised?
That issue is perhaps redundant.
How many posts were advertised, Mr. Bora? Huh? What was the breakup? No, what was the breakup of the categories? $21. Okay. Where is the breakup? How many posts were advertised? 9.
14, madam.
14 posts.
Para 25.
Para of the writ petition. Para 25. You are general, Mr. Chakravarti, you are general.
My lord.
Now tell me, the power of the selection committee to make this change. If the advertised something is something else, and where is the power of the state selection committee to make this change? Show me the power. It is only because of this change you have come in. How can the selection committee change the prescription? Where is the power? Selection committee is not the appointing authority. No, tell me, there is an order, but now there is a challenge to that. So we can go into that issue.
He has not given any.
You are general.
Against me, nothing, madam.
No, you tell me your right to get the appointment.
Serial number 5 on the.
OBC, how many posts of OBC was 8? How can they have 8 posts for OBC? Why 5 posts? Initially that was not there. No post for OBC was earmarked. Yes, this is by the selection committee only this has happened. So the whole thing went for a toss.
OBC.
No, 6 OBCs were appointed. No, six OBCs were appointed.
Is there in 8.
Now there is an order, we can do nothing. So you don't,
Before filing this.
you don't-
I was joined, madam.
you be there. Don't open. It may give you
That's the.
just why. That you have to say something, that is why. Heard Mr. B. Chakraborty, Learned Counsel for the petitioner. Also heard Mr. R. Borpujari, Learned Standing Counsel, Finance Department, appearing for the respondent number 1, 2, 3, 4. Also heard Mr. S. Chauhan, Learned Counsel, appearing for the respondent number 5, and Mr. N. Bora, Learned Counsel, appearing for the respondent number 6. So, the petitioner, by way of instituting the present writ petition, has assailed an order dated has assailed orders dated 11/8/2014 and 19/8/2014 issued by the Director of Audit, Assam, cancelling the appointment effected in his case wide order dated 14/12/2012. Also, the brief facts requisite for adjudication of the issue arising in the present proceeding is noticed as under. Also, the respondent number 5 here, 5 herein had approached this court by way of instituting a writ petition being WPC number 611/2012, assailing the appointment effected in case of the respondent number 6 herein and 1 another. Also, the said writ petition was taken up for final consideration, and a coordinate bench of this court by judgment and order dated 15/5/2014 proceeded to allow the said writ petition by directing for appointment of the respondent number 5 herein, and for the purpose, it was also stipulated that it would be permissible to remove the last general candidate who is the present petitioner. Also, it was further stipulated in the order that in the event it is necessitated to remove the present petitioner, he would have to be put on notice explaining the reasons necessitating his deletion from the select list and his consequential removal from service to make way for appointment of the respondent number 5 herein. Also, in pursuance to the passing of the order dated 15/5/2014, the respondent authorities issued the order dated 11/8/2014, removing the name of the petitioner from the select list, and thereafter proceeded to issue an order dated 19/8/2014, cancelling the appointment effected in respect of the petitioner herein, while order dated 14/12/2012. Also, being aggrieved, the petitioner has instituted the present proceeding. I have heard the learned counsel for the parties and also perused the material available on record. Mr. R. Borpujari, learned counsel, appearing for the learned standing counsel finance, appearing for the state respondents, has placed before this court a written instructions retrieved by him. At the outset, this court notices that on filing of the instant writ petition, this court, wide order dated 10/9/2014, order dated 10/9/2014, while issuing notices in the matter, was pleased to suspend the impugned orders dated 11/8/2014 and 19/8/2014, and the said interim order continues to operate as on date. Full stop. Mr. R. Borpujari has placed on record a written instructions received by him, which reveal that the petitioner herein, as well as the respondent number 5, petitioner in WPC number 611/2012, are both continuing in their respective services. It is to be noted that in pursuance to the directions passed by this court in the earlier writ petition, in WPC number 6119/2012, the respondent number 5 herein was appointed as a peon cum chowkidar in the office of the Assistant Director of Audit, local fund Tezpur Circle, Tezpur, wide an order dated 26/3/2015. Post up, the petitioner, who was initially appointed as peon cum chowkidar in the office of the Assistant Director of Audit, local fund, Silchar Circle, Silchar, was allowed to continue to serve in the said establishment in pursuance to the interim orders passed in the matter. First up, the respondent number 6 accordingly is also continuing in his service without any hindrance whatsoever. Also, in view of the above position, the accommodation of the respondent number 5 in terms of the directions passed by this court wide the order dated 15/5/2014 in WPC number 6119/2012, apparently not requiring the removal of the petitioner herein and the appointment effected in respect of the respondent number 5 being against a post other than the one held by the petitioner herein, which reflects that there were vacancies available for accommodating both the petitioner and the respondent number 5. This court at this distant point of time would not interfere with such arrangements made by the respondents in the matter. Full stop. In view of the above position, the impugn orders dated 11/8/2014 and 19/8/2014 bracketed annexure Roman 14 and Roman 15 to the petition stands set aside. Full stop. The petitioner as well as the respondent number 5 and number 6 shall be allowed to continue in their respective services in terms of their original order of appointment. Full stop. The services of the petitioner shall not be disturbed in terms of the directions passed by this court wide the order dated so and so 15/5/2014 in WPC number 611/2012. Upad arota likhi basu. Also, it is found by on perusal of the materials brought on record. What side of this court notices that while issuing the impugn orders dated 11/8/2014 and 19/8/2014, the petitioner was not put to notice, although there was a clear stipulation in this connection made by the coordinate bench of this court wide the order dated 15/5/2014 in WPC number 6119/2012. With the above observations and directions, the petition stands disposed of. Yes, Mr. Bora, now everything is happy. The instructions furnished by Mr. R. Borpujari, learned Standing Counsel Finance, is kept on record and marked as X for the purpose of identification. Where is she?
Delhi, Your Lordship.
When is she coming?
After a week.
A prayer is made on behalf of Ms. D. Ghosh, learned counsel for the petitioner, for an adjournment in the matter on the ground that she is out of station. Prayer accepted. Registry to list this matter again on 18/11/2025. I'm ready to pass the order. Okay, we'll pass it in her presence.
Yes, Your
Mr. Munir, both of you, examine one aspect. We can give some relief. We'll try to give some relief. There are two posts, development officer and district officer. Development officer in charge, from that in charge, again in charge district officer. Right? Now, what is the hierarchy of the post? Inspector, development officer, district officer. Right? Hierarchy is in that line?
Yes, Your Lordship.
Initially in 2002, he was inspector.
From that, what is the hierarchy?
Yes.
Inspector, development officer, district officer. Right? You have any rules? Do you have any rules? Not anything, Richard. Just show me that. Where do I get this development officer? Direct recruitment 50, promotion 50. Which is higher, district officer or development officer?
This one will be the development officer, then district officer. it goes from below, my lord, marketing officer, development.
No.
Development officer is in
Where do I get it?
class page, my lord, class 2.
Hmm. And this district officer? He is also class 2.
Class 2.
So you were development officer first, then district officer.
Yes, your lordship.
He was, yes.
How? Which is higher? District officer is higher.
In the same,
Consider this. If we can give you some pay, maybe if we can show that it is from development officer to district officer, work on it. Otherwise, nothing, no retrospectivity. It's a great idea. Sir. Give him a copy also. Do you have this copy? No. You give him a copy.
I'll give you.
Give him a copy.
In-
Okay, next day.
For industry development officer is there, and in the village oil industries. Development officer.
No, find out what is the hierarchy. Just give me that thing. Because you have, he was development officer, then asked to take charge as district officer, Guwahati and Darang. Now, if that is the higher post, you have promoted him there. Then what happened to the in-between post? You should have taken care of that also. Not with retrospective effect, but something so that he gets at least a fixation there and then a fixation during promotion, some pensionary benefits. That's all. Okay. There was a Supreme Court decision.
Lordship,
What is that?
lordship, this is lordship.
What is the ratio there?
Lordship, paragraph 22, lordship.
So your prayer's gone.
After passing of the judgment, lordship, pass the judgment, lordship. Supreme Court judgment.
So you want this judgment?
Lordship,
But Mr.
he board lord,
P. Bodley, Learned Council, your board cases.
only for 9, lordship.
Who is for 10? Okay, it'll go together.
Lordship,
9 and 10. Huh? Hut Mr. P. Bodley, Learned Council for the petitioner in WPC number 683/2015. For none has appeared for the petitioners in WPC number 1220/2014. Mr. J.K. Goswami, Learned Additional Senior Government Advocate, appears for the respondents in both the writ petitions. So, the Learned Council for the petitioner has fairly submitted that the case of the present petitioners, the case of the petitioners in the above noted writ petitions is covered by the decision of the Honorable Supreme Court in the case of Grah Rakshak, Home Guards Welfare Association versus State of Himachal Pradesh and others, reported in 2018 6 SCC 247. So, he submits that following the decision of the Honorable Supreme Court in the case of Grah Rakshak bracketed Supra, Grah Rakshak Home Guards Welfare Association, Supra, this court, a coordinate bench of this court in the case of Kamakhya Das and others versus State of Assam and others, the wide ordered judgment dated 8/8/2022 in WPC number 4267/2022 has disposed of similar writ petitions. Accordingly, he praised that similar orders be passed in the present writ petitions also. First off, the above prayer is not objected to by Mr. J.K. Goswami, learned additional advocate, learned additional senior government advocate appearing for the state respondents. First off, I've heard the learned counsel for the parties and also perused the materials available on record. First off, this court this court in the case of Kamakhya Das, the coordinate bench of this court in the case of Kamakhya Das, after noticing the decision of the Honorable Supreme Court in Grah Rakshak, Home Guards Welfare Association, bracketed Supra, had passed the following, had disposed of the writ petition in the following manner. Para 7, 8, 9. So, the petitioners herein being similarly placed like the petitioners in the case of Kamakhya Das and others, this court is of the considered view that the present writ petition be also disposed of with the following direction. First off, the petitioners in the above noted writ petition be extended with duty allowance at such rates, total of which 30 days, bracket a month, comes to the minimum pay or to which the police personnel of a state are entitled to. So, the respondent authorities shall pass appropriate orders authorizing to the petitioners in the above noted writ petition the said benefit within a period of 3 months from the date of receipt of a certified copy of this order. First, with the above observations, the present writ petitions, the above noted writ petitions, with the above observations and directions, the writ petitions number so and so stand disposed of.
Interim order was there, Lordship. Order is a
The interim orders passed earlier stand vacated. Mildo?
Right, Your Lordship.
Itu tomorrow, Lilo. Itu তুমি মারা পিছত এই হাতত item
Upadhyay, my lord. He is out of station. So Lordship may incline.
I'm sorry, why was this not made known to this court yesterday? Should have made it known yesterday. We are going to hear it.
He has also informed me on Saturday,
Oh, both are Raji.
Saturday he has also informed me. So
And you could have informed me, I would not have gone through it.
also not prepared, Lordship. The matter is of 2015.
You want women reservation. What is the decision? One post, you are SC.
I'm a C.
One post, 30% would be 0.3. If it's not one, how are you entitled?
I am an SC.
You're SC.
Yes.
SC, as per the advertisement, one post.
One post,
So 30% of one would not be more than one.
more than one.
So how can you get it? Women reservation is category as per our act.
That woman reservation was not a part of the advertisement.
Need it not be. Now we will provide it. But whether you can be accommodated, you can't be accommodated in general, you cannot be accommodated in OBC. You will come in SC only.
Yes.
If it is SC, only one post, how can that be applied? Show me that.
Lordship.
Mr. Ardhor, you get the files. We'll hear Mr. Ardhor. If that is afterwards required, only we will hear Mr. Upadhyay. Kali Thursday.
That's it.
On the prayer of Mr. Ardhar, learned a counsel appearing for the petitioner, registered to list this matter on Thursday. Just satisfy me on that point. Be with you. You have prevented the family welfare department from doing welfare, huh? You have prevented them from coming. They are not here. Modeler.
Yes, my lord, modular 4. There is distinction, my lord.
But the pay commission has, there are two categories of pay in the commission report. One is with qualification X and one is without qualification X. What is the error in that?
Currently, my lord, yes, going by the rules, my lord.
You make a challenge to the rules. You have given up the challenge. Now, when the ROP says that this is the thing, how can we interfere?
Prior to that rule, my lord, coming into force, and after that, my lord, there are judgments of the Supreme Court saying that how the classifications is to be made or how it is not to
But
be made.
the Supreme Court judgments also say that educational qualification can be a criteria for a higher pay.
Yes, in case of promotion, yes, that is true, my lord.
No, no, no. In case of higher pay also, in a same cadre, you can be given higher pay, provided there is a higher qualification. In the rule, it is prescription is made.
But, my lord, going by the Randhir Singh and others, my lord, 82, the judgment, there is a,
Pay parity. Randhir Singh is not with regard to the same people in the same cadre.
yes, it is, my lord. Para 8, my lord.
Randhir Singh has been. Para?
8. May I read? The principle of equal pay for equal work expressly declared by Constitution certainly is a constitutional goal. Article 39D of the Constitution proclaims equal pay for
No, this was Delhi police.
Yes, yes, my lord.
They wanted it with similar pay with other
Other.
departments.
Yes, my lord.
Now, show me a law which says that there cannot be two pay scales in the same cadre or in the same post on the basis of qualification. That much only.
May I draw one more attention of your lordship, my lord? Subsequent to this, my lord, exercise, my lord, recent advertisement in 2023, they have now, my lord, equalized all grade pay and also, my lord, homogeneous educational
They
qualification.
have given you that also.
No, I'm not giving, my lord.
Why?
So far as the respondent, private respondent is concerned, my lord, he's getting higher grade pay. And this is only,
Where is the latest advertisement?
yes, my lord. Kindly come to my affidavit in reply, my lord,
Page?
page 68. So, my lord, 67 it starts, 68, my lord, serial number 23. Modeler, HSSLC with training in model from government recognized institute. This is the pay band, my lord, 14,000 to 60,500.
When was this advertisement issued?
In 1/2/2023.
5,600.
Yes, my lord.
Yes, Mr. Upamanyu. Why the brothers and sisters in the same family being discriminated? Okay. Let Mr. Gogoi come. Where is the ROP rules? Yep. You have
So,
annexed
17,
this,
my lord.
no, that RFE rules which were
2010.
initially under challenge.
I have not challenged the ROP rule. my lord.
Okay. Now, where you have the ROP rules here somewhere?
Yeah, I have the copy, my lord.
Just give me. Where is your appointment order?
And my lord, at page 24 onwards, my lord, 24.
You are modular 4.
Modular 4. Another question, my lord, in the rules also, my lord, there is no distinction of modular 1, 4, 2, 3, 4, my lord. Only modular. It says only modular.
And where is the appointment of the private respondent?
well, page 27.
Initially, they were both given the same scale of pay.
Yes, my lord.
Then, where was the increase made?
After joining, my lord, they followed the 2011 rules. It started giving them the higher grade pay, my lord. And prior to that, my lord, kindly come to the advertisement for a minute, for a moment, my lord, page 23. Kindly see the qualification, essential qualification needed. Page 23, HSSLC pass, diploma in the preparation of medical embryology models from a recognized medical institute, or experience of preparation of medical models from a medical college, or diploma or degree in fine arts from a government institution with years experience in sculpture or preparation of models in plastic and fiberglass. Now, similar, there are two posts. One is modular 4 and one is modular 1. For which category, my lord, they have invited degree and diploma? That is also not clear from the advertisement.
That is for both the posts. One is central photographic come audio visual unit creation.
Yes, sir. Yes, my lord. This is for modular 1.
And
Creation
both the
number-
posts, there is only 5 in both modular 4 and modular 1.
Yes, my lord.
The vacancy is shown single,
Yes.
5 posts. Okay, fine. And the petitioner was also appointed as
Modular 4.
modular 4, autonomy creation, number 120. Okay. 120, okay. But what do you say about these rules?
Yes, well, your lordship is right. Perhaps I should have challenged the rules also during that time. But subsequent to that, when 17 came into force, my lord, ROP rule 17, they have made a distinction again, my lord.
Where? Show me. That ROP is 17. Because this is permissible. Again, the same thing is maintained. But now the gap has gone up. 6,200 and 7,400.
One more aspect, my lord. Perhaps by this fact, my lord, the whole argument will come to a sense still, my lord. I have nothing to add. My lord, kindly come to page 41 for a moment, my lord, of a writ petition. And this is a letter, my lord, from the DME to the Secretary Government of Assam Health, my lord. It was a query, my lord. Perhaps I am not the other reference letter with me, my lord, but this is a query on what basis, my lord, the differentiation of pay was made. So he writes in, kindly see, my lord, number one answer. Yes, the work function of the artist modeler and artist projectionist are same. What photographer is different. Number two, the posts were created in different pay scale of the categories, perhaps either through oversight or not properly examining their duties and responsibilities at the time of creation. Then number three, my lord, the person holding this post is basically engaged for art-related matters of teaching work. For appointment against the post, the identical education qualifications are required. Now, my lord, if we relate these things to the judgments of the Honorable Supreme Court, my lord, yes, they perhaps cannot make any differentiation. Because we are doing the same work, my lord.
Yes, Mr. Borpuzari. You are the creator of this problem.
The additional is
Both the matters. Okay, we'll take it up after some time.
an affidavit. Be illustrated.
Just a moment, just a moment. Nurses in the medical college, they are also distinguished in terms of qualification. Where do I get it? 2010 ROP, 2010 ROP. It should be there.
I have the 17 or
BSc is given a higher qualification. Just find that out also. Let Mr. Gugoi come. So this is your case.
I will cite some judgments also.
Okay, fine. You give it back when the matter is taken up finally. Yes, Mr. Roy. What is this happening? There are periods of suspension in tune with the criminal proceedings term. But those criminal proceedings all resulted in his acquittal. Can you show the other way? No. It's all acquittal. Even after retirement, the period before that, suspension, subsequently acquittal. Now, once it is acquittal, you'll have to give him the complete pay.
After the High Court. The Honorable Court has passed an order. Verified. Order mean that he will not work. So she will kindly have.
Look at it. Those are all interim nature's orders because the criminal case was pending. Now that the criminal case is over, we'll not go into that. Once the criminal case is over, it's a suspension. How will you deal with that? There may be interim orders passed by this court while considering an application whether he should be reinstated, wherein the cause of the suspension still continued. Today, the causes are gone. And even after that.
After that, it was regularized.
Mr. Chavan, your periods after 90 was regularized?
After
No.
that, the payment was made. There is no order specific. Order, my lord will kindly have.
Fair mailer to regular.
That only 87 to 90. Thereafter,
Mr. Mr. Chavan, Mr. Roy, Mr. Chakraborty, sit down together for 10 minutes, work out what is left out. Both of you agree, come back. That's the only, you're not going to get your promotions. I'm sorry. That you will not be entitled now. But areas of pay, whatever it is there, and a consequential revision in your pensionary benefits, that this court will provide. Provided you give me the complete details. We'll take it up at 2. Please have that discussion made. Promotions, Amal Sattapati, latest decision. We can't guarantee you retrospective promotion today. I'm sorry.
Retired 2010.
When did you retired in 2010? You come up before this court after around 5 years.
My lord, the criminal proceeding.
Heated as it may, on the date you had gone, that day you were legally not given your promotion because there was a proceeding pending. Criminal case. Criminal case, now we'll have to see whether it was a proper acquittal on doubt. Why should we go on? This thing we are giving you. Just work out that. Each period, you make a statement that this is the first period, this is the second period, this is the third period. This I have got, this I have not got, or this I have got. Whatever it's, give it to me, we'll pass the order. At 2. No inconvenience, Mr. Roy?
18.
Yeah.
Bring it on record. You better just for me. Now you have retired. You have retired, Mr. Kolda. You have retired. Hmm? So what is there? Nothing is there. But now I can't put you back, can you? You have been, you were continuing as principal. What is the department proceeding against you? Peter resume, what is it today? Because that appointment was interfered by this court. Now you'll have to be freshly appointed. How can you be appointed if there is a... What is that department proceeding? Oh, this is not invalidating your earlier thing. Earlier thing we have interfered with. Now it goes back. Now the court has accepted that, okay, fine. This is the reason why Joint of Borman will have to be given. Now Joint of Borman will have to be appointed afresh, which he cannot be because there is a pending proceeding against him. No, that selection was interfered with by this court. Was it not interfered?
Yes, my lord. That was in.
So this is in pursuance to that interference afresh. Now you have got it, fine. You will have to be now appointed afresh. We'll hear it. Get that proceeding what it is against you on record. You have got this copy of this order.
Distribution of my lord, uniform.
Peter does it, man.
The president did not sign.
Now, any error in this order? No error in this order. So that the review that you are seeking for is now academic. Is academic.
That interference must.
Both cannot go together now. Either one will remain. No, either this will remain. If I interfere with that, then this will also go. Because this is a result of that only. So today, if I interfere with my order, I say, no, it's bad, I recall it. This automatically goes.
Of this finding.
Can't do that. No, no, I can't. That will not be. Which one? Oh, it will come. You're still in service. 30th of this month. Okay, let me apply my mind. Budbar. Make a mention if the list is long, make a mention, we'll take it up early on Wednesday. Only on this point, I'll just want to apply my mind, that's all. On the prayer of the Learned Council for the parties, registered to list this matter again on Budbar. By slip koi diba kali, Budbar to Kali hobo na? Thursday. Kali file to deliver. We'll apply.
Madam. File an affidavit that he has attended the classes.
No, no, no. That now is gone. We'll go by the government's finding. Let me see how we can do it. Yes.
In this, we are praying for a review of your lordship's judgment. Judgment starts at page 55 minutes. Initially, the challenge in the writ petition was that these two petitioners, they were denied the charge as a principal on the ground because they have acquired the qualification without the NOC. Lordship decided that issue. Now, while deciding that, my lord has declared at page 63, my lord, paragraph 23
Of the order.
of the order. Para 23, my lord. Applying the ratio of the decision of this court in the case of Tankeshwar Nath Supra, it is held that MA degree acquired by the petitioner having been so acquired from a recognized university, the said degree is otherwise valid and acceptable in law. And accordingly, the petitioners are held to have fulfilled the eligibility criteria as mandated for recruitment to the post of principal of Nazira Girls Higher Secondary School, Nazira, under the provisions of Rule 12.3 of the Assam Secondary Education Provincialized Service Rules 2018. Now, my lord, Rule 12.3.5 prescribes, my lord, that the incumbent should not be more than 7 years as on the date when the post fell vacant. Now, while examining, my lord, the eligibility condition, my lord, in terms of this direction, my lord, we call for a document verification, and thereafter from the service book, it came to light, my lord, that his date of birth is 1st of July 1966.
So he is not entitled.
Yes. On the day when
What about the petition number 2?
well, the direction was only for the
We'll modify that direction.
petitioner number 2, my lord, as there was no direction, we have not examined it yet.
We'll modify that direction. Can we pass that order in the review itself?
I think no, my lord, because this review, my lord, the direction was
Okay,
entirely
we'll have
in
to
respect of
recall
the
this
petitioner
order.
one.
Okay. We are recalling this order then. Wait,
Court number.
Thursday. We'll recall this order because there is no other way out, because on the date of passing of this order, he was not eligible. That was not brought to the notice of this court. Petition number 2, that would be a fresh consideration now. You make your submissions whether I can do that halfway. Okay, Thursday.
Can it be Friday, my lord?
Friday. Okay, Friday.
Grateful, my lord.
Save it. Heard the Learned Council for the parties at length. Case judgment reserved. None appears for the petition. All of Pishotla. We'll wait for the petitioner. Mr. B.J. Ghosh, Learned Counsel for the petitioner is present. However, there is no representation on behalf of, there is. Yes. Any final orders passed?
No, my lord.
Why? Why final orders have not been?
Ready, lordship, just because one.
Where is that interim order?
0531, order detail.
Order dated? Where is the interim order?
This in 6053, lordship.
Hmm.
In this case, my lord, we have challenged the propriety of the seizure procedure. My
No, where is that interim order? What is the nature of that interim order?
interim order, my lord, no coercive action should be taken. That's because here we have changed the very propriety of the seizure procedure, my lord. So in that case, the this order was passed.
22?
One.
No, it 11/10/23. Coercive action against the petitioner
Yes,
till
yes,
the next date of this.
yes. Done our part, lords. And that is 100 of.
Hmm. Hmm.
At the time of short sales, they are not.
Hmm.
From their side, but. This is not an independent witness, man. The accord provides that there should be an independent witness present when the search and seizure to maintain the sanctity of the search and seizure, my lord. So that has been settled by the Supreme Court also, Honorable Court also, my lord. I'll please to judgment, my lord.
So there are two cases. One is 319.
And 319 is regarding, my lord. After that, when they initiate the inquiry proceeding, my lord, lordship is aware, when the inquiry proceeding, all the materials which are going to be used against me, that should be furnished to me, my lord. All the document, all the statement on which they have relied on, my lord, that should be furnished to me, my lord. I applied for, I asked for, my lord. They said, I will show it in the course of hearing, at the time of hearing, my lord. Whether that is, my lord, the compliance with the principle of natural justice, my lord. Whether that is a fair opportunity of hearing, my lord. So the proceeding we have challenged, my lord. That inquiry the proceeding.
What
that
is
we
the
have challenged.
provision in the regulations or rules, whatever it is that, that what do you call that?
My lord will
The
say
Assam
cancellation, section 50, rule 15.2, my lord.
cancellation is articles order.
Article
18.2.
order 15.2, my lord.
15.2.
Yes, yes, yes. 15.2, lordship will say. Lordship has got it, my lord. No order of cancellation should be made under this clause unless the license given a dishonorable opportunity of stating his case against the proposed cancellation. What is, my lord, the opportunity of hearing, my lord? They have done two inquiry. First,
Okay, fine. We'll take it up for disposal.
Lordship will take up this matter on
Why?
any date in the next week, lord.
On the prayer of Mr. P.D. Nayak, Learned Additional Advocate General, appearing for the state respondents. Registry to list this matter again when? Monday? Thursday. Thursday, I think we have a little bit more. Let us have it on Monday. Monday, 17/11/2025. Mr. B.J. Ghosh, Learned Counsel for the petitioner, is present. Tuta Ekalagiri Diva. So basically there are two. One is with regard to the Caesar and the other one is with regard to the proceeding itself.
Proceeding itself, my lord. Whether the proceeding can.
And with regard to the transfer of the PDS beneficiaries,
Yes, my lord.
that they have already passed
Yes,
an order that you have
I'm
not
on that.
challenged.
I'm not on that, my lord.
And two, also tell me that one of the allegation against you is recovery of PDS cards from your shop.
Yes, my lord.
Whether you can retain PDS cards.
We have explained it in our affidavit, my lord. We have explained it.
We'll see.
Investigation.
We'll see. We'll see.
Two inquiry was made. One was ended in my.
And you say independent witness. One of the witnesses was your witness.
He cannot be in my humble submission, subject to lordship's correction, whether he can be treated as an independent witness, my lord. Otherwise, all official witness.
Okay, then 29.
sir.
Well, what question is, my lord, whether this question was but BSc in medical lab technology is equivalent to, my lord, BSc in physics,
One
organic
thing,
chemistry.
one thing. I don't have the power or the wherewithal to declare a equivalence. That declaration of equivalence has to come from the respondents. Now, your case is that AIIMS Delhi has adopted some rules, or act wherein they say that BSc technology, BSc in zoology, chemistry, maths is equivalent to
Plus
BSc
medical lab, diploma in medical lab.
plus diploma is diploma in 5 years, 5 years, or BSc in 8 years, 8 years service.
No, 8 years is different, man. That is category number 2. my lord.
Okay, 5 years.
5 years.
And the AIIMS Guwahati says that no, we have in our regulations only BSc medical lab technology or something with 5 years of service. Now, why should
My lord,
the
this is the recruitment rules of
no.
This is
The advertisement specified only BSc medical technology or lab technology, whatever it is.
or equivalent, my lord.
Where is that?
Advertisement.
Where is the advertisement?
Page 31. my lord.
Okay.
Page 32, my lord.
32. BSc,
In medical lab technology or equivalent. My lord,
now show me the admittance of equivalence by
my lord,
the,
kindly have a look at this is the rules, my lord.
Of
The
the-
AIIMS Delhi rules.
we'll
must
go
follow
by
the-
AIIMS. You
No, my
have
lord.
a separate regulation here?
Well, AIIMS Delhi categorically stated that their rules must be followed by new AIIMS. The rules, my lord.
No, I just want to know whether you have a separate regulation for your posts?
But I have to obtain instruction. Here I have not.
No, in your affidavit, have you said so?
My lord, 2015 AIIMS Delhi rules, my lord, is categorically stated that all these new AIIMS were established in the line with AIIMS New Delhi. They are asked to follow the extent recruitment rules of AIIMS New Delhi. These are rules, my lord. Kindly have a look, my lord.
But this medical lab technology, that is a course of duration. What is the duration of that course?
It is 5 years. 5 years.
5 years.
5 years.
And your BSc nursing, BSc,
BSc 3 years plus 2 years diploma course. Equivalent to 5 years.
where is that? I want that only. If it is a diploma,
2 years
then it
diploma.
becomes 8 years.
Now, 8 years is not as a category number 2, madam. Category 1, madam.
No, that BSc plus diploma is enough. Where do I get it?
Madam, BSc in medical lab technology are equivalent.
Huh.
plus my lord 5 years experience in concerned field.
So
Or-
BSc is equivalent to,
BSc plus medical lab technology 2 years is equivalent to BSc medical lab technology. Madam. There's a category, or this is different. It is 8 years, I am not concerned, madam.
so, okay. This is the stipulation in the,
So this is the aims rule, madam. Where it is categorically stated, madam, all the new madam, aims has to follow. The non
okay, now you see here, BSc in medical lab technology or equivalent and 5 years experience in concerned field. Now, where do I get this prescription that BSc in medical lab technology equals BSc zoology, maths, chemistry plus diploma? Where do I get that?
Madam, kindly have a look, madam.
How do I interpret that, Mr. Khanigar?
Madam, page 39.
This court will also have to examine that whether this is prescription is evident from the advertisement, because there may be many people who have BSc plus diploma in medical lab technology who may not have applied.
Madam, kindly have a look at page 42, madam.
What is the date of this?
That is the All India Institute of Medical Science, madam.
The advertisement is dated
17/11/2023, madam.
23. Okay.
Can I look at page 41, madam? Can I have a look? So this is a report of the coordination committee for bringing uniformity in the recruitment rules for various non-faculty posts, their nomenclature, qualification,
Okay.
and pay scale of
Okay.
AIMS New Delhi.
Okay. So AIMS
Madam-
New Delhi has a recruitment rule and there was a committee set up to examine that. Okay, fine. Then what happened?
That's page 42, madam. Can I look?
Okay, this is the recommendation.
This is the recommendation.
Now, whether the rules, the regulations were amended?
That means equivalent, my lord.
No, it will have to be brought in.
If madam, AIMS Guwahati has the madam separate rules, madam. And I have no.
No, they have said so.
I have no case, madam. But Delhi, madam, Delhi,
Having
AIMS,
PSP,
Delhi rules
so
must
and so,
follow,
so
madam.
and so, so
All
and
the,
so. Regulations, review, rule.
otherwise, madam, AIMS Delhi rules must follow, madam. Must be fair.
Where do you get that?
That introduction, madam, I have, madam, art. And madam, this examination was conducted by the AIMS Delhi, madam. PRE AIMS, madam.
Just give me a moment. Okay. Okay, Mr. Gogoi, how have you made these statements here? This requirement that you have specified that this is our requirement. And those things not being amended in the rules, we are not. What is the basis for that requirement? That basis with regard to the qualification?
Lordship, it is,
When? Before this election or after this election?
but that's my itself, Lordship.
No, that prescription that you are not going to adopt equivalence,
Equivalence part is there, Lordship, equivalence part, but that.
what would be the equivalent then? In terms of this BSc in medical lab technology or equivalent?
Lordship,
What would be the equivalent?
BSc in medical lab technology with equivalence. 5 years experience in the concerned field, Lordship. Diploma in medical lab technology or equivalent, equivalent part, Lordship, that part experts have decided.
You need not. But once you have said equivalent and in Delhi and Delhi aims, because this recruitment was conducted by Delhi.
It says centralized recruitment process, Lordship.
Mm.
Aims and respect aims has verified all educational testimonials.
We'll get it. We'll come to that. Now, the recruiting agency, if had found that he had the requisite qualification in terms of the prescriptions made by them. In 2015 itself, they have made a prescription that BSc medical lab technology equals BSc zoology plus diploma in what do you call that?
Medical lab technology.
Diploma in medical lab technology plus 5 years.
5 years.
And if it is only diploma, it is 8 years. So 3 years taken away by that thing.
They are not the recruiting agent. They have advertised the post, Lordship.
Who has made the recruitment? They have made the selection. Selection was made by?
All of the, as I realized, Lordship, all the aims, Lordship, examination of by the Lordship, Delhi aims, Lordship. After that, Lordship, it was selections and appointment of the.
Now, whether in any of the aims, a similarly situated person with this qualification was recruited.
Otherwise,
You will have to have done, we will have to have the instruction, because if it is one selection, the criteria will be same for all the aims because you don't have a separate criteria. Now, if this medical BSc zoology was adopted, say in Rishikesh, say in Bhubaneswar,
that is there. Otherwise, Lordship, that particular proposal was, Lordship, only the coordination.
I'm not on that. I'm not on that. This is one. AIMS Delhi is conducting the recruitment for all. Now, they all will have uniform qualification.
Lordship.
Now, you cannot say that I will not accept a person with BSc zoology and diploma in technology, and Bhubaneswar will say, no, I will accept. Rishikesh will say, I will accept. You don't have that power.
Otherwise, Lordship also kindly paid the recommendation part 2016. Recommendation was done and advertisement was done, Lordship.
No, no, I only want to know, Mr. Gogoi.
That's the point of Lordship.
23 advertisement was done.
23. But what is the, Lordship, requirement is given, Lordship.
That is different.
Recommendation was not taken by consideration by Delhi aims also.
Mr. Gogoi, I just want a clarification whether Delhi, while considering this qualification for the purpose of equivalence, had taken BSc also. And then that was uniformly applied to all. And there were others than the petitioner with the similar, because he has made a statement, no materials. That person similarly situated like the petitioner, say, was nominated to AIMS Rishikesh, was nominated to AIMS Bhubaneswar, and he was appointed and he is working. If that is so, we'll have to allow it.
Otherwise, Lordship, the document is very clear. Recommendation was made in 2016.
And also, Mr. You are an autonomous body. You have a post in your establishment. Now, how is that conditions of that post regulated by you? Just have that.
Only one point,
Otherwise,
page 35.
that coordination.
I got it. I got it. But if it is adopted by the selection committee for all, then
If it is adopted, it should be for all. There is no dispute, there is no controversy. Otherwise, advertisement itself says recommendation of Delhi was 2016.
because
Advertisement
here
of-
we don't have an affidavit from Delhi, we have an affidavit from Guwahati.
Lordship. That's
So-
what the issue is in the.
Guwahati. So how is Guwahati saying that? Guwahati should have a rule of their own. wherein they have said,
There is no rule. See.
then when you created the post, what was the conditions attached to that post? Just get it.
Page
Two.
kindly have a look at page 35.
Two. Friday? Friday?
Next week.
Tuesday. 30?
30.
30 page?
Page 35.
35.
The allotment, my lord. Allotment letter, my lord. It's not selection, it's the allotment. The selecting.
After that, verification was done. After that, all the MCF lordship.
Just show me whether this was a condition applied in respect of all or that
Only for
only that selection was done, the document was not verified, those was supposed to be done by the concerned aims and you found not, then you did not give me. But you found it not to be equivalent on the basis of what? Because that word equivalent therein, you have put a word equivalent. It has to be given a meaning. What is that meaning?
otherwise the affidavit
Just get that
I'll get.
on the prayer of Mr. D. Gogoi, Learned Counsel, K. Gogoi, Learned. You are appearing as the CGC, Learned CGC, appearing for the respondents. Registered to list this matter again on
Last week of November, lordship.
25,
Lordship.
25/11/2025. Mr.
Lordship on 27.
27, okay, 27/11/2025. Mr. Gogoi shall clarify as to the basis on which the authorities of IIT, no, AIMS, Guwahati had held the equivalence that had held that the qualification possessed by the petitioner was not equivalent to the qualification spelt out in the advertisement, that is apostrophe BSc in medical lab technology.
Recommendation was led.
How do you get it? Why should I put it? You get it because that is nothing. You write full stop. Mr. Gogoi shall also apprise this court as to the basis on which the petitioner was selected by the selection committee and as to how the selection committee had held the qualification possessed by the petitioner to be equivalent to that of a same Busutu. Same Busutu. BSc?
I have no difficulty petitioners get the job, lordship.
No, we should be very sure.
Lordship.
I'm only saying that when there is a word equivalent given, it has to be given a meaning. What is that meaning? Okay.
Deep level.
Due to an urgent matter.
2 o'clock. 2 o'clock. Medical instructor, the instructor social and English. Earlier decision of this court have put them in one category. They are all eligible for promotion to supervisor. No appeal. So how can you deny them? That much only Mr. Das has to explain. Mr. Bhattakur is here?
Yes.
2 o'clock. Abhijan? Come on, also, what? Oh, it to Duta was at Ahana, no? Mane. 11 to tomorrow, yeah, no, any pay parity. 12 to into Goyahana. That was it. Thomas about matter. No, well, no, sir. Mr. Soma, your item number is 26. Huh? Vedanto Deca.
I will continue. It will take time, my lord. It is lengthy brief.
What can we do?
Comfortably.
You are there?
Our senior is there, Kina.
No. You are there, take notes. It's a departmental proceeding matter. Yes, Mr. Sharma.
Here the punishment imposed is compulsory retirement.
What is the charge against you?
Charges are as many as 14 charges, my lord, all is their own circular and
33.
my lord, let me first,
How many charges?
14 charges.
14 charges, okay.
There is no allegation of any default, fraud, misappropriation, anything. And what I say is, I did exactly what is prescribed under the KCC loan system, as well as the Mudra loan system by the government of India. Come to that, my lord, let me first take a lawsuit to few paragraphs of my petition.
Okay.
And the was issued my lord, after 4 years of my transfer from the bank to other bank. In the meantime, I was also given a commendation number of times. Yes, that is 2020 also. My lord, he was appointed on 30th of September 2013, my lord. And after passing the examination, he was earlier in the Bajaj Alliance and HDFC Bank. Then he contest on All India service level. He got the was appointed as Agriculture Finance Officer on 13/9/2013 in the Central Bank of India. Then he was, my lord, transferred to finding his meritorious service within 3 years. He was promoted to the post of branch manager, Skill 2 in 2016 and posted as branch manager in Kanpur branch. And he was there till 10/6/2018, my lord. That will be important, my lord. 10/6/2018. Paragraph 1 I am reading. 10/6/2018 will be here. On 10/6/2018, the petition was transferred as branch manager to Morigaon branch of the bank. 2020, he was transferred as a recovery. He was transferred as recovery recovery department manager, regional office, Upper Assam, region Jorhat. That petitioner was awarded commendable certificates for record performance while he was posted in Kanpur branch of the bank by the bank's higher authorities, which go to show that the petitioner proved meritorious service throughout until 2020, when he was illegally sought to be made actually it should be scapegoat, my lord, by some interested, vested interested in the bank. Copy of the recommendation, my lord, there is as many as 5. As late as 2020 also, after my transfer after 2 years, I was highly commended for my service, as well as in the recovery of my of the NPL loans. On 2/5/2022, the petitioner was posted as zonal office, Pune, as manager, which is to assume to be a promotional post. Then, my lord, shockingly came the order, my lord, on 16/7/2022. 4 years, more than 4 years of my transfer from the Kanpur branch. He was transferred in different departments, and he was also given the promotional post in 2022 itself, 2/5/2022. That on 16/7/2022, local charge sheet was.
We have seen that, Mr. There are 14 charges against you.
Yes, yes.
During the inquiry, all the 14 were proved.
No.
How many was proved?
Some were partly proved. Some were, so you will have lots of kinds of
Where is the inquiry report?
report is, my lord. I filed the written statement, my lord, in detail. long instrument. By report, yes, it's 93, my lord. 93.
Hundred and two. That is the inquiry report. Starts from 103.
Sorry, 93 is staff accountability policy.
90?
Please stop accountability policy. Important. Because lots of through that also. 102 years.
This is what you have submitted. Okay, let's see how the conclusions were drawn by the inquiry officer.
There are some allegations, my lord. Some charges brought by inquiry officer which were not in the charge sheet also.
Okay, that we'll have to go through.
My lord, it starts from 103.
Hmm.
Imputation charges, charge number 1, Mr. Vedanta has sanctioned and allowed with disbursement of 149 CKCC accounts without adhering to standard lending norms of procedures. Charge number 2 is my lord, Mr. Decca had sanctioned CKCC to Mr. Sophia Khatun so and so without adhering to standard lending room norms of the procedure.
Mr. Sharma, with regard, no, Senior Sharma. So what is the error with regard to the conclusions drawn by the inquiry officer with regard to each of the charge?
My lord, error is my lord, you also see many of the charges were said not proved.
Fine.
And some were partly proved. Partly proved also, it will also goes to the.
But there were certain charges which were held to be proved also.
Yes. And partly proved also, my lord.
Hmm. And not proved also.
Is not proved.
So what do you make out of that?
Now we'll also go to page 116.
116.
Last, my lord, right hand column of that. On scrutiny of arguments of submitted by PO, Presiding Officer NDR, it can be concluded that not all 145 FI accounts linked with KCC were opened during the
So
service of
that
Mr.
76 was opened in your period. Because of that, it is partially proven.
And
So it is 141.
141. And opened during the service of Mr. Priya. Rather, 76 FI accounts linked to were opened during SOE. Charge seated officer employer what? Hence the imputation was partially proved. Then, my lord, next charge is not proved. Third is proved. No, my lord, there is no allegation of any fraud or cheating or misappropriation.
All the accounts have been rendered NPA. So it amounts to a loss.
All recovered. So the full recovery was there. Yes, I say on oath.
Where?
Yes. In the reply also, I have said.
Where? Against this report, have you?
All recovered. In the WS also I have said. The reply to the charge sheet also I have said. My report I have said.
And during the inquiry, did you ask any of the officers about this? Did you put question that the amounts that are there are already being recovered? So where is the anomaly? Any cross with regard to that?
So there was no cross assessment. There was no actually my lord, what happened?
That was something you should have put before the.
The presenting officers submit something and the DR, defense assistant, submit something. There was no examination, any witness, anything.
No. There was.
Yes or not examined, my lord?
PO
Or,
brief.
from
DRT.
the petitioner, I say.
No, there is. MW1,
Yes.
he is one of the evidence, one of the witnesses. Through him, these documents were produced. Now, whether you have cross-examined him.
Cross-examination, nothing. Actually, I was not asked also to cross-examine.
And that you had your witness, defense assistant also. So if the witnesses have brought on record evidences and the conclusions have been drawn by the learned, by the inquiry officer basing on that, without there being a apparent error being shown, how can this court, perversity being shown, how can this court interfere with that?
Sir, if the charges are in terms of the, my lord, their own rules and, my lord, their own circulars and memorandum, then it's all right. But what is the, my lord, the,
But that has to be established in the inquiry, Mr. Sharma. That has to be explicitly brought on record in the inquiry.
I have, in my WS, I have brought thoroughly,
And the huge financial loss is around 1.8 crores,
no loss,
0.8 crores. That is the, or somewhere I found.
no loss.
So you have been only given a penalty, a lenient penalty.
Requirement.
Hmm?
The requirement
Compulsory.
is not the lenient, it is a major penalty.
Yes.
Now you'll also kindly come to.
What is the, Mr. Shama, let's see, what are the errors? What is your stand?
You will also kindly come to page 93.
Hmm.
And I have said, my lord, in my WS also, in my NPA became after I was transferred, and Mr. Jitesh Kumar responded for took over. And he did not attempt to recover the amount. Till my stay there, up to 10/6/2018, there was full recovery, there was no loss. It's well stated.
Okay.
My petition also.
Hmm.
I will also kindly come to page 23, 93.
I'm in 93, you can.
Sub-accountability policy in NPA accounts. Well, I needed 13.1.2. Risk taking forms an integral part of business in banking institutions. Therefore, every loss caused to the organization either in pecuniary or other forms need not necessarily become the subject matter of staff accountability. At the same time, it would be unfair to ignore motivated or reckless decisions which have caused damage to the interest of the organization. Therefore, a distinction has to be drawn between business loss arising in the normal course of bona fide commercial decision and a loss which has occurred as a result of any malafide, motivated or reckless performance of duties. While the former has to be accepted as an integral part of the business and ignored from the accountability point of view, the latter part be viewed adversely and dealt with under the extent staff accountability and dismissal procedure. Then, my lord, 13.1.4 is to be ensured that those delinquent staff members who are found primarily accountable directly or indirectly of misconduct or moral turpitude or working against the interest of the bank or misusing their position of authority should be sternly dealt with in accordance with the bank's rules and regulations. Now, I will come to 13.21 credit portfolio. Freshly slipped NPA account. Account which turned NPA within 18 months from the date of sanction, including enhancement of credit facility, takeover, first disbursement, whichever is later, quick or accounts. Moreover, however, in following conditions, even if account is in standard category, competent authority may get staff accountability examined and initiate further action if merited. This were everything. These were not done. Serious observation, major irregularities. Put in internal account or concurrent statutory audit, vigilance, RBI inspection. After I left Manila, 2 years accounts were held. 3 years, 16, 17, 18. There was not, the auditor did not find anything against me during the period of my stay in that bank branch. Let them put his audit report. There should be part of record.
Okay, you mean to say after in view of the staff accountability position, after 2 years or 3 years, whatever you detect, you cannot relate it back to the person who was there prior to 3 years.
Yes. Audit report will disclose everything, my lord. Audit is not done by me. It is by bank authority. Then my lord also kindly see 13.2.3 accountability of the successor. Staff accountability will also cover inaction on the part of the new incumbent in the branch region officials to own responsibility in respect of all matters handled by previous incumbent, especially monitoring and follow-up of pending matters, existing advances, SMA, NP accounts, recovery proceedings, etc. Besides these acts of omission, failure on the part of any staff in initiating recovery actions, taking action under surface, etc. to ensure fixing reserve price or scale will also attack staff accountability. Efforts made in this respect need be well documented. So I was succeeded by my lord on 11th of 10th of evening. My lord, respond for Ritesh Kumar. What he did. Still, my still there was not a single NPA. So my on affidavit. My lord, 13.10. 13.8 will also come, page 98. Accounts which have turned NPA within 18 months of sanction, so and so and so. All these quick mortality accounts with sanctioned limits of 1 lakh and more. Staff accountability shall be examined on the same line of freshly slipped NPA accounts. The quantum of sanction limit in such accounts shall decide one of the procedures detailed herein before, to be followed by the concerned competent authorities to consider ordering investigation and thereafter examining staff accountability. However, in respect of such accounts with sanctioned limit of up to of 25 lakhs and above, investigation shall be carried out invariably within a period of 3 months of account slipped to NPA. Areas of banking and other operations. Then Milo come to 13.10, page 99.
Okay, Mr. Sharma, we got your point. Your case is that this very show cause could not have been initiated against me.
Yes. Now, one.
Can you do one thing? Can you just make a list? Allegation charge number 1, your stand, and the finding of the inquiry officer. 3. This, if you can make a chart with the page numbers, it will be very easy for this to quote. 14 charges, few of them not proof, so you can remove that. Charges proved, you can do it. The charge is like you have not taken the proper documentation, photographs of the units. You have denied it. But after the examination of the witnesses, it was found, you said that the loans were running properly. The amounts were coming. So there was no situation of rendering it NPA. After you have gone, you are not concerned what has happened because that's for the officers. One charge is that you have issued loans beyond 25 kilometers. I think that has not been proved. But the other charges, they say that because there is no documentation, because there is no proper maintenance of records, the recovery of the loans have been hindered. So that's basically the charge, and they come to an estimate of around 1.08 crores. So, Mr. Sharma, if we find that you were not very prompt in your services, may not be having a wrong intention, but your actions led to a loss. The situation would be you're a bank employee. Your method of working will be higher than the others. Faith, integrity, everything would be a notch higher. Then the question of loss of confidence come in. If there is a loss of confidence of the bank on you, that's the end of the matter.
Bank and insurance company finance loss of confidence is gone. Then it is gone. And one more thing, my lord, you will also go through the norms prescribed by the government of India for
No, because I'm still telling you, I did not go through the evidences. That is not my, until and unless you can show perversity.
Yes.
I don't find from your pleadings perversity as such. But Mr. Sharma can always show me that this conclusion is perverse because of ABCD.
Yes.
Otherwise, I'm not going into the evidences and the conclusions drawn by the inquiry office. I'll have to take it
Yes,
on the
yes, sir,
page.
my lord, only the products are produced, my lord, there is no.
No, there was a witness. There were management.
Yes, the witness produced the document.
That's true. That's the procedure.
Now I'll also.
But you have not cross-examined them. That's the problem.
Since there was no only my lord, production of documents, there was no examination chief. So cross-examination.
No, there was examination chief. I've gone through. There is examination in chief.
Simply documents are produced, my lord.
No, there is examination in chief. He had produced with a certain, you should have crossed him because that document, once it is produced, it becomes evidence.
No, only production document will not become evidence.
He has produced it. Maybe he has said, this is the document.
Anyway, on that point, my lord, whether the judgment of the Supreme Court and also this court, that even in the Department of Proceedings, my lord, evidence should be as strict as, my lord, in the civil case, like, my lord, the contents of the documents, not only the production documents. Production and exhibiting the documents is not enough.
The Supreme Court judgment, as far as I have understood, is that if the document is produced by the presenting officer,
yes,
it will be only production of the document. But if that document is produced through a deposition of a witness,
yes,
then it becomes an evidence.
no. If the document is, my lord, produced by the deposition witness, proving the contents of the document,
No, really prove. He'll only have to cite.
Since it is a voluminous brief, my lord, I could have gone go through the Bankers Evidence Act. So I looked because in Bankers Evidence Act, so far I know in earlier cases I for.
Please, we want to know, learn from you.
Stick proof like other cases need not be there. So I'll also take a loss of through that one.
During examination in chief by the PO from the reply of question number 95 by MW1, which pertains to MEX number so and so, it is evident. So there was some, you get the records for me, wherein this statement of the witnesses are there.
Including the audit report, my lord.
That we'll see. But the statement of the witnesses are not here on record, I suppose, Mr. Sharma.
Not based on the audit.
The statement of the witnesses are not here. Deposition, it's there. You can get the departmental file.
Yes, sir.
But Mr. R.P. Sharma, Learned Senior Counsel. Mr. Sarfi Sharma has made his submissions. However, the hearing remains inconclusive. Mr. M. Sharma, Learned Standing Counsel, Learned Counsel appearing for the respondent bank, submits that he would produce the inquiry file on the next date of listing. Accordingly, registry to list this matter again, on 18/11/2025 for
It will
further
be bit longer,
20.
the end of the November.
27/11/2025 for further hearing. You get the records. You get the records. Because Mr. Sharma, if there is evidence adduced in the manner it should be, and you have not dislodged it, departmental proceedings, I think preponderance of probability we
No,
cannot
it
go
is
up.
true, my lord. If the evidence or whatever document is produced, that is against the norms prescribed by the bank, then I am free.
That you satisfy.
Item 12.
No problem. No problem. Yes, Mr. Chakraborty. Yes.
Lord, so far as the petition is also modular 4.
Hmm.
Otherwise, modular 4, my lord, there is the ROP.
Hmm.
Without diploma, one is with diploma.
Hmm.
They are getting in 10 also, here also, 2010.
You mean to say that this is a consistent division? But what do you say, whether this is permissible? Earlier it was around 400 rupees, now it has, but they were doing the same work. Show me certain judgments of the Supreme Court which permits you to do that. No, no, because that Assam Fishery Development, Fishery Officers Association case, wherein the graduates in BFFC degree and BSc, they were given two different skills. But this court, my Lord Justice Gogoi, long judgment, 2000, had held that no, they are doing the same work, so there cannot be a disparity. And this is also a tune which is there in the Supreme Court decisions also. So, what do you say on that? That's what I want.
That Jagdish Singh's case.
Have to report those. You're relying on citation?
In one SCC, one period.
Para?
Charge, my lord.
This goes against you. Hmm.
Work, which there, my lord, this part will
Duties, responsibilities, status, everything same.
determining equality of equal pay for equal work.
This is a distinction being made in 42.1 is with regard to the post in one department and that one in another department. Hmm. Para? Hmm. This is again Mr. Gogoi within two different posts, not within the same cadre.
Promotional.
under the principle of equal pay for equal.
Now, do you forget the rules, forget the ROP rules? You have a rule of recruitment rule of your own, which governs the post in question. There is no rule for them.
I'm told, my lord, this applies, my lord, Ministerial District Establishment Service.
That will not apply. It's a medical college. So the recruitment conditions for this post are the same. Now, with regard to BSc teacher, BSc nurses, there was a disparity, but that has been done away with. What was the order in the single bench before the single? Is under challenge. Any orders passed? Please.
The Nayak is there. Found, my lord, cited in the affidavit was the respondent number 6. Great way.
Fully ground taken.
Is my lord.
But this judgment will not help you. There are a few judgments with regard to PRO and
There it is very clear, even in the same establishment.
can be done. It can be done. Yes, that can be done. You place that, we will.
Yeah.
SC Chanda citation. That judgment says so. This thing is not working. Net problem. Net coming.
Equal pay for equal.
What alive will believe. Okay, you just get hold of that judgment. We will see. Yes, Mr. Chakraborty, what is your case?
My lord, all these judgments, my lord, the main point, my lord, that is coming out, my lord, is that in between two different posts, in two different cadres.
We are not concerned with that. There is a line of judgment
Yes,
of the
my lord.
Supreme Court within the same cadre.
Yes, my lord.
There are two rules provide that if you are a graduate, you are promoted in 5 years. If you are a diploma holders, you are promoted in 3 years. Like that. From the feeder post to the higher post. So the Supreme Court, where it was put to challenge, Supreme Court said no, that is permissible.
Yes, my lord. Classification can be done, but subject to, my lord, the source of recruitment, my lord, the nature of work is being performed, the quality of job is being performed, my lord. These are the essential ingredients that has to be looked into, my lord, before making a classification. In that sense, my lord, that anomaly committee's report of 2011, my lord, perhaps was wrong, perhaps, my lord, because based on that anomalies committee's report, my lord, 2017 ROP came into force, my lord. Now, in my petition, my lord, I have prayed for a notification of that notification, by which, my lord, this different grade pay was being, my lord, introduced.
But that would amount to a challenge to the ROP
Technically, yes,
rules.
my lord. Technically, yes.
So that you have given up here.
That I've given up, my lord.
So this court cannot go and consider that again to be also a challenge here. Now that you have given up and that is recorded. If it is so, it would have gone before the division bench. You could have argued the matter in that lines. Any decision which says that.
Yes, my lord. Yes, I'm coming to that, my lord. Now, my lord, I have already submitted the compilations, my lord. And I have
Compilation.
already, my lord, referred to Ranjit Singh, my lord, that my lord has already noted, my lord. Ranjit Singh versus Union of India, my lord.
These judgments, 5.
Yes, 5 judgments I have cited.
Randir Singh is not helping you.
All right, my lord. Ranjit Singh, my lord, this is the one judgment, my lord. Then, my lord, I come to, my lord, there is another judgment of Gujarat High Court, just for reference, my lord. Gujarat High Court, my lord, this is Bin Praja Rajya Prati Technical Karmachari Mandal versus State of Gujarat, my lord.
Para?
And my lord, para, in the very first para, my lord, that's I'm just reading, my lord. By way of filing this petition has challenged the action of the state government, whereby the anomaly has been created by the state government by introduction of 2 different categories of the same post of planning assistant in the town planning and valuation department, right? Notification dated so and so, whereby those employees who are having qualification of degree in civil engineering / architecture have been placed in the pay scale of so and so, whereas employees who were having the diploma in civil engineering architecture but doing the same work have been placed in a lower grade of pay scale of so and so. Now, my lord, then, my lord, para, this is the crux of the matter, my lord, and para 8. Para 8, my lord, says, before proceeding with the matter, the fact which is very clear is that the recruitment rules are framed under Article 309 of the Constitution of India, wherein the qualification for appointment of planning assistant is degree in civil engineering or diploma in civil engineering. When the recruitment rules specifically prescribe both the qualifications, in my view, having different pay scales only on the basis of educational qualification is contrary to the rules, which are statutory rules. In that view of the matter, the distinction made by the state government on the recommendation of the high level committee on the ground of educational qualification is contrary to the statutory rules.
Okay, then
When both the persons
we got it. Then
my lord,
next.
the second line, my lord. When the next line, my lord. When both the persons holding different qualifications are appointed under the same rules and are holding same post, the decision of the state government in prescribing 2 pay scales for the same post is contrary to the law and violative Article 14. My lord, this is one judgment. Then another, my lord, that is Punjab State Electricity Board and another versus Thana Singh and others, my lord. It says, my lord, para 18.
Para
18, my lord. Married. The appellant board, an autonomous body governed by its own regulations, it was for the board to classify its employees' post on the basis of qualifications, duties, and responsibilities of the post concerned. If the classification has reasonable nexus with the objective sought to be achieved, the board would be justified in prescribing different pay scales. Article 14 of the Constitution of India would be applicable only when a discrimination is made out between the persons who are similarly situated and not otherwise. It is a duty of an employee seeking parity of pay to prove and establish that they have been discriminated. In State of Haryana versus Tilak Raj, the court held that to claim a relief on the basis of equality, it is for the claimants to substantiate a clear-cut basis of equivalence and a resultant hostile discrimination before becoming eligible to claim rights on par with the other group of vis-a-vis and alleged discrimination. Then, my lord, next para, 19. The person claiming parity must produce materials before the court to prove that the nature of duties and functions are similar and that they are entitled to parity of pay scales. After referring to a number of judgments and observing that it is the duty of an employee seeking parity of pay to prove and establish that he had been discriminated against, this court in Sale held as under, it is a duty of an employee seeking parity of pay under Article 39D of the Constitution of India to prove and establish that he had been discriminated against, as the question of parity has to be decided on consideration of various facts and statutory rules, etc. The doctrine of equal pay for equal work, as enshrined under Article 39D of the Constitution, read with Article 14 thereof, cannot be applied in a vacuum. The constitutional scheme postulates equal pay for equal work for those who are equally placed in all respects. The court must consider the factors like the source and mode of recruitment, appointment, the qualifications, the nature of work, the value thereof, responsibilities, reliability, experience, confidentiality, functional need, etc. In other words, the equality clause can be invoked in the matter of pay scales only when there is wholesale identity between the holders of two posts. So this is one observation, my lord.
This was in comparison of one category of post with the other.
Then, my lord, in referring to this judgment, lord, the fact situation in my case, my lord, this is a DME's opinion, my lord, that I have already referred to you, to my lord, page 41, wherein he says, my lord, the responsibility is same, my lord, similar, doing the same job. So, my lord, there could not have been a distinction between a graduate modeler 4 and an high secondary pass modeler 4, my lord. That is absurd, my lord. Then, my lord, another judgment, my lord, Delhi High Court. That is, my lord, Nishant Chawla versus Telecom Dispute Settlement and Appellate Tribunal and others. Para 34, my lord. Para 34, my lord. May I read, my lord? In Federation of All India Customs and Central Excise Stenographers versus Union of India, so the Honorable Supreme Court observed on the question of equal pay for equal work. Equal pay for equal work is a fundamental right, but equal pay must depend upon the nature of the work done. Cannot be judged by the mere volume of work. There may be a qualitative difference as regards liability and responsibility. Functions may be the same, but the responsibilities make a difference. One cannot deny that often the difference is a matter of degree, and that there is an element of value judgment by those who are charged with the administration in fixing the scales of pay and other conditions of service. So long as such value judgment is made bona fide, reasonably on an ineligible criterion which has a rational nexus with the object of differentiation, such differentiation will not amount to discrimination. It is important to emphasize that equal pay for equal work is a commitment of Article 14 of the Constitution, but it follows naturally that equal pay for unequal work will be a negation of that right. And again, my lord, next page, my lord, it has relied on Ranadhir Singh, my lord, I have just quoted, my lord. And in the next page, my lord, just down below, just referring to a para, my lord, as their claims for better scales of pay did not meet with success, the said application was filed by the petitioner for the issue of a writ under Article 32 of the Constitution. It was allowed by the court, Sinappa Reddy Justice, speaking for a bench of 3 judges of this court, reiterated the following principles. Now, my lord, principle A, equal pay for equal work is not a mere demagogic slogan, but a constitutional goal capable of attainment through constitutional remedies by the enforcement of constitutional rights under Article 32 of the Constitution of India. B, my lord, the stand of the Government of India that the circumstances that persons belonging to different departments of the government is itself a sufficient circumstance to justify different scales of pay, irrespective of the identity of their powers, duties, and responsibilities, is unacceptable and untenable. Next, my lord, while equation of post and equation of pay are matters primarily for the executive government and expert bodies like the Pay Commission and not for our courts, where all things are equal, that is, where all relevant considerations are the same, persons holding identical posts may not be treated differentially in a matter of their pay merely because they belong to different departments. Next, my lord, the principle of equal pay for equal work is not an abstract doctrine when applied to government servants performing similar functions and having identical powers, duties, and responsibilities.
Come to para 35, that
Yes.
8. Para 35 of that
Yes,
same.
35. The principles with reference to similar posts under same organization has been discussed by the Honorable Supreme Court in Mewa Ram Kanuzia versus All India Institute of Medical Science, my lord. Then, my lord, while considering the question of application of principle of equal pay for equal work, it has to be borne in mind that it is open to the state to classify employees on the basis of qualifications, duties, or post concerned. The classification has reasonable nexus with the objective sought to be achieved. Efficient administration, the state would be justified in prescribing different pay scale, but if the classification does not stand the test of reasonable nexus, the classification is founded on unreal and unreasonable basis, it would be violative of Article 14 and 16 of the Constitution. Equality must be among the equals. Unequal cannot claim equality. Yes, my lord. That is true, my lord.
Come to 8. that same
Yeah,
paragraph.
there are
35.
several decisions of this court where educational qualifications have been recognized as a valid basis for classification. State of Mysore versus P. Narsingh Rao, this court held that higher educational qualifications such as success in SSLC examinations are relevant considerations for fixation of higher pay scale of tracers who had passed the SSLC examination, and the classification of 2 grades of tracers in Mysore state, one for matriculate tracers with higher pay scale and the other for non-matriculate tracers with lower pay scale, was held valid. It is pertinent to note that matriculate and non-matriculate tracers both constituted the same service performing the same duties and functions. Yet the court held that higher pay scale prescribed for the matriculate tracers on the basis of higher educational qualification was not violative of Article 14 and 16 of the Constitution. In Union of India versus Dr. Mrs. S.B. Kohli, the classification made on the basis of educational qualification for purposes of promotion was upheld by this court on the ground that the classification made on the basis of such a requirement was not without reference to the objective sought to be achieved, and there could be no question of discrimination. State of Jammu and Kashmir versus Triloki Nath Khosa, cadre of assistant engineers included degree holders and diploma holders. They constituted one class of service, but for promotion to the post of executive engineer, only those assistant engineers were eligible for promotion who possessed bachelor's degree in engineering, and our diploma holders were eligible only if they had put in 7 years minimum service. No such restriction was prescribed for degree holders. The diploma holder assistant engineers challenged the validity of the rule on the ground that it is denied them equal opportunity of promotion in violation of Articles 14 and 16 of the Constitution. On a detailed consideration, a constitution bench of this court upheld the classification on the ground of difference in educational qualification. Court held that classification founded on the basis of educational qualification had a reasonable nexus to achieve administrative efficiency in services. The court approvingly referred to the decisions of this court in State of Mysore versus Narsingh Rao, Gangaram versus Union of India, and Union of India versus Dr. Mrs. S.B. Kohli. The court upheld the classification and refused to grant any relief to diploma holder engineers. Mohammad Sujad Ali versus Union of India, another constitutional bench of this court, upheld the classification of supervisors into 2 classes, graduates and non-graduates, for the purpose of promotion to the post of assistant engineers on the ground of educational qualifications. Although both the class of supervisors constituted the same service, in Federation of All India Customs and Central Excise Stenographers Recognized versus Union of India, claim of personal assistants and stenographers attached to the head of departments in the Customs and Central Excise Department of the Ministry of Finance for equal pay in parity with the personal assistants and stenographers attached to the joint secretaries and officers above them in the Ministry of Finance was rejected by this court on the ground of the functional requirement of the work done, training and responsibility prescribed for the 2 posts. State of UP versus so-and-so, the question arose whether it was permissible to have 2 different pay scales in the cadre of branch secretaries for persons performing the same duties and having the same responsibilities. In the light of the various decisions of this court, it was held that the principle of equal pay for equal work has no mechanical application in every case of
That is
similar-
one decision which goes against you, 1989.
But my lord, it has already stated, my lord, the classification made and what is the nexus between the, my lord, classification made and the objective to be achieved, my lord. That is important, my lord. In this case, my lord, the objective to be achieved is the same, my lord. We are doing the same job, my lord. There should not have been any requirement of a degree holder, my lord, for the job. So that is the crux of the matter, what I have understood, my lord. Anyway, my lord, in the next case, my lord, that I have referred, my lord, that is.
Bihar's case.
Yes, my lord. There is only some limitations, this, my lord, prescribed when court has to go slow, my lord. At para 68, my lord. Although, my lord, this is a job of the executive to be, my lord, done, my lord, but still, my lord, the court has to look into certain things, my lord. Para 68, may I read, my lord? Analysis of the decisions referred to above shows that this court has accepted following limitations or qualifications to the applicability of the doctrine of equal pay and equal work. Number 1, the doctrine of equal pay.
You are reading para?
Para 68, my lord.
68 is that Bihar case. State of Bihar versus Bihar secondary.
Yes, fellow, State of Bihar.
68 is something else. He also submitted that with effect from 3/7/2012 under the rules Frame, it was obligatory for every teacher.
I'm sorry, Malad.
You are
That
reading-
copy, Malad, maybe SSC, Malad. I'm
Ah.
having Patra, Malad.
For monopole.
Malad, maybe just say, Malad. Side issue.
This is after, basically,
2019 husband.
no, you are reading that part, after the submissions or?
After the submissions, yes, ma'am. Towards the end, Malad.
Okay, how does it start?
Analysis of the decisions.
Yes, 96.
Yes, ma'am. Analysis of the decisions referred to above shows that this code has accepted following limitations or qualifications to the applicability of the doctrine of equal pay for equal work. Number one, the doctrine of equal pay for equal work is not an abstract doctrine. Number two, the principle of equal pay for equal work has no mechanical application in every case. Then the very fact that the person has not gone through the process of recruitment may itself, in certain cases, make a difference. Next, my lord, the application of the principle of equal pay for equal work requires consideration of various dimensions of given job. Thus, normally, the applicability of this principle must be left to be evaluated and determined by an expert body. These are not matters where a read court can lightly interfere. Then, my lord, granting pay scales is a purely executive function, and hence the court should not interfere with the same. It may have a cascading effect, creating all kinds of problems for the government and authorities.
Yes, that is
Yes,
a general,
yes,
general,
my lord.
general.
Next, my
general.
lord, equation of post and salary is a complex matter which should be left to an expert body. Next, my lord, granting of pay parity by the court may result in cascading effect and reaction which can have adverse consequences. Next, my lord, 9 and 10. These are important for me, my lord. Before entertaining and accepting the claim based on a principle of equal pay for equal work, this court must consider the factors like the source and mode of recruitment appointment. Next, my lord, in a given case, mode of selection may be considered as one of the factors which may make a difference.
Got it, Mr. Chan.
Yes, my lord. So this is my submissions, my lord. And I would also like to refer again, my lord, the DME's opinion, my lord. Para
Page
40,
41. Let us go through that.
Page 41. In a reference, my lord, I don't have that letter, my lord, but this has been replied back. Stating that the work function of artist, modeler, and artist projectionist are same, but photographer is different. Posts were created in different pay scales of the categories, perhaps either through oversight or not properly examining their duties and responsibilities at the time of creation. The person holding this post is basically engaged for an art-related matters of teaching work. For appointment against this post, the identical education qualifications are required.
No, this is comparing the modeler and the artist projectionist.
Yes, two posts, my lord. And perhaps, my lord, because of these things, my lord, in the recent advertisement of 2023, my lord, they have, my lord, equated all my lord, grade pay.
Where is your advertisement? It's on record.
That, my lord, page 23, 19 to 23, my lord, of my petition. Starts from 19. 12/4/2010, my lord. The qualification criteria, page 23, my lord.
Now, page 19, 13. Modular 4.
Modular 4.
This is your post?
Yes, modular 4.
And the qualification is at?
Page 23, my lord. 23 is the original one, my lord. Translated, type copy, my lord, is at 19 only. Oh, it will. Oh, yes. Number 23.
Finance has filed any affidavit here? No. No?
Well, in the chart, we ROP 98 to or diploma holder.
You're not diploma holder.
Certificate holder.
Certificate.
Certificate.
The respondent number 6 is a degree.
The degree holder. Posts are created, my lord, in 2010.
So modeler was there.
Creation number.
There was it there.
That is there from earlier. Maybe for that institution that was created. Okay.
Net pay as that.
That is a
Honors to
see, Mr. Chakraborty's case is simple. That okay. No, his case is very simple. He says that the qualification per se, qualification would be a ground for discrimination, but per se that will not be. We'll also have to look in method of recruitment and the objectives sought to be achieved. In your pleadings, I don't find a single line saying that a person with a degree, we find him to have to give a better output. It cannot be. There has to be.
That's why I'm saying, well, that's why all my lord.
If I remember, in nurses' cases, the distinction was a BSc nurse is better placed to do the required intricate works. So, justified. Now, where is that similar justification here? You mean to say they can, he can come down, but they can't go up.
Difference is, that's the reason. If we are down, my lord, to their grade. How they are entitled?
Is respondent number 6 a party here?
Yes.
You are appearing.
Yes.
Has been stated that, my lord. So we are giving that part.
No, in your this thing, what do you call that department? In your department, in the medical, there are many posts wherein this dual pay has been fixed. Because this judgment will have a wide-ranging effect then. Okay, let us wait for, because the division bench is also seized of a similar issue in respect of the nurses. Let us wait for a few days, because you say the matter is being heard today. Mr. Monto is there? No. No, Mr. Monto, who is the counsel? SC Chanda, that 89 may give you some. My mistake. Yesterday night, when I was going through the file, by the time I reached this, it was late. So I made a note that I'll take out the judgments today morning. I forgot.
There, my lord, with me, my lord.
No problem, no problem. One submission of Mr. Chakraborty really attracted me is that whether the comparison only can be limited to the qualification or there has to be something more. This is an attractive. No, what happens, the consequence is different, but whether we'll only have to declare whether this disparity is proper or not. Okay. We'll give it a thought, Mr. Chakraborty. We are not rushing into it. We'll give it a thought.
Yes,
we'll have it.
All Assam nurses.
That is going on. So let that conclude. We'll give it a week's time. But that will also have a bearing here. Let us have it on next week, say Thursday. Heard the Learning Council for the parties also. Submissions remain inconclusive. Registry to list this matter again on 20 Bistari.
30th of November.
20th November.
28.
20.
All right.
Bistari, December, this 20. Yes, Mr. Roy, any middle way?
But, so for prayer number A, my lord, can the prayer, my prayer.
Okay, prayer
Prayer,
A.
my lord, is page 12. First prayer, my lord, to regularize the suspension period.
On this one, then the annual increments.
Then, my lord, the annual increment, where, my lord, the respondent also.
A, B, C, D, we are with you. But E and F, I'm sorry, cannot be granted.
My lord.
71A, yes.
Now, therefore, the undersigned of all pay and allowance onwards, including area.
So the period from 87 to 90 was that regularized?
That, my lord, allowance
That,
and
that has to be.
Yes, yes.
So that periods will have to be regularized and the increments have to be given. And his final, that will have a bearing on the final outcome also, pension also
Yes, if the increments are given, definitely the pay.
will go up. So now,
My lord,
I've
one-
just gone through it.
my
I've not
lord,
gone
page
through it deep because there is a lot of facts here. Now, one thing, Mr. Roy, there is no punishment given to him which would have the effect of justifying the suspension. All the proceedings gone in his favor.
DP.
No DP, no, I'm with the criminal case also. Each
Criminal
and every criminal case went in.
That automatic, my lord,
It's automatic. It's automatic. Why I'm saying so? It's automatic.
honorably.
That I think in the case of suspension and this thing will not come in.
Suspension.
Although,
Yeah, we are only. I'm not with the promotion. I'm with the suspension only. So if that be so, everything gets back to him. He is entitled to the period regularization of the suspension with pay and increments till the date of his retirement.
Notional, because just because the
Of the proceeding, that goes.
It goes.
He comes back. And the withholding of the increments was because of that only.
Obviously, my lord, obviously. That I cannot. My lord, approve this.
page 50, can you see, my lord, the page 50 additional agreement. My lord, because like, my lord.
Mr. Chakraborty, can you make a list from when he was stopped, increments were not given, whether it was given, what was given, so that I need not go into it. I'm taking a help. We can just consider it and pass the order. Please do so. When should we put it?
Any day, my lord.
Next week? Let us put it on the 20th. No, this writ petition, from the writ petition and the affidavit. I don't want you to go to the records. Just from the writ petition and the affidavit.
On my lord.
On 20th? 20. Heard the Learned Council for the parties at length, registry to list this matter again on 20/11/2025 for further hearing.
Pattern, my lord.
Huh? Further hearing, I said.
Let it be 19, my lord.
19. Okay, 19, no problem. Just give me that breakup. And you give a copy to Mr. Chauhan. Before that, if he has anything, he can, then we'll finish off the matter. Because I only examined that whether he was in any way convicted in any, there is no conviction. So the suspension being a precursor to this allegations, I don't think so.
All the criminal cases, my lord,
Everything
that
went in your favor.
the accountant, I issue check only. After approval of higher authority, that was the
So
fact.
anything, it was like anything happening there, you were picked up. Anyway, you get back. But the promotions, Mr. Chauhan, I'm sorry.
Your lordship, the issue petition has already resolved by this honorable court. Your lordship may kindly give flag the judgment, your lordship, earlier round of litigation. Your lordship.
That. Yes, who is appearing? Who is appearing? Your case is that the earlier case was the
Mathematics, your lordship. Inspector-
mathematics, social studies and English.
No, earlier by the mathematics, your lordship.
In that judgment,
Judgment.
consideration is there of these three posts.
Hmm.
These three posts, the consideration is there, and then it was held that these three posts are from the feeder cadre for supervisor, and the final conclusion and the direction is only with regard to instructor mathematics, because that was the person before them. Yes, Mr. Das. Why this discrimination between two brothers and sisters?
Yes.
He is not, he is relying. Any appeal?
Yes.
Appeal filed. Then?
That was for the post.
No.
Supervisor.
No.
No, they were senior instructor.
No. They were instructor. They were instructor. They were not senior instructor, Mr. Das. Show me where it is said that they are senior instructor. I may have got it wrong. You just clarify that.
Once it comes to our service rule.
3. Page 77.
Regarding rule
3C 3.
4.
4.
4.
3(1)(c)(4).
1C4. Excellence. Dot. Here we have the cadres. Senior instructor comprising post of instructors, instructor, mathematics. What included here, my lord? Technical instructor, related instructor, senior instructor drawing. But my lord, this special study.
Now you come to the conclusions drawn by the Honorable Single Judge.
Before that, your lordship may kindly peruse para 18, your lordship, for consideration
Para 18 of you?
of the judgment, your lordship.
That's where coming to that. Very elaborately dealt with judgment.
Para 18.
core issue which arises for consideration in his case, as has already been noticed at the very beginning of the judgment, and which should fortified in the course of hearing, is whether the post of instructor mathematics in which post the petitioners are serving or similar other posts, such as instructor social studies, instructor English, etc., included in the cadre of senior inspector, as mentioned in Rule 3(1)(c)(4) in the 1983 rules. Then, Your Lordship, para 26, Your Lord. And para 27, that being the position and having regard to the discussions made above, it is hereby declared that posts of instructor mathematics and such other similar posts would be included in the cadre of senior instructor as appearing in Rule 3(1)(c)(4) of 1993 rules, following Rule 24 of the same rule. That's conclusively decided already.
Will kindly,
Para 2. Okay. Now you take me, Mr. Bothakur has shown me. Now you take me. Ah.
husband.
Hmm.
The core issue of the which deals with the cadre of
Hmm.
enforcement training service. The short point which the post of instructor this was the core issue, my lord.
Okay, fine.
Yes.
Fine. Now come to para 19.
This lordship schedule, my lord. One.
Of the? Okay, 91. Hmm.
9. Fine. My mechanical
Now there are, according to your submissions before the coordinate bench, there are two posts of mathematics. One is mathematics technical, instructor mathematics technical, and another one is instructor mathematics normal. Right? The court examine that issue and then see the conclusion.
what lordship one.
I got it.
That is not mentioned here, madam.
Ah.
Okay, in the rule.
You come to page 102. of the judgment, internal page 11. It's a continuation of para 16. Just come down 1, 2, 3, 4, 5, 6, 7, 8 lines.
Madam.
No, top 8 line. A distinction is sought to be made.
Of applicants working.
Forget that. You come to the straight away to 102, 8th line. After counsel, J. Islam. So this is the point noted. Arguments advance, the point noted by the Honorable Single Judge. A distinction is sought to be made between the post of so-and-so and so-and-so. So-and-so is a non-technical post and cannot be equated with the so-and-so, which is a technical. It is contended that instructor is one post and there is no nomenclature so-and-so. Duties, responsibilities of senior instructor mathematics and instructor mathematics are not the same. Qualifications are different. So this was not something which the court had not noticed. This court had noticed that. And then now you come to para 18.
My lord, the rule, mathematics.
Now that is also taken care of in paragraph 19. Huh? So this rule was taken, the post forming therein was broken down, and then para 20. And the rule was read by you as in para 20. Huh? With regard to that comma, this court went and examined. Now see from para 21, how it has appreciated the contention of the petitioner with regard to the posts forming the feeder cadre and your perspective on that.
Done by my APSC.
Oh, I only have to now, because this is binding on me. And you have made your arguments. So these points that you are arguing have already been taken note of by this court. Now see in para 21, read para 21.
Yes. Sir. Mathematics is concerned. Qualification prescribed was SSLC pass and 3 years diploma in mechanical.
Or
Hello.
science graduate.
Graduate, yes, madam, science graduate.
It is seen that she was appointed as mathematics instructor, so and so, so and so, so and so.
ATI pass.
The same pay scale was given to senior instructors from the schedule. It is evident that pay scale provided for the instructor senior qualification prescribed for are also identical. Now, para 22, comma. The identified instructor as a separate post within the cadre of senior instructor. Instructor can be instructor mathematics or instructor social studies, etc. Now, this conclusion of inclusiveness of these three categories of posts has attained finality.
They
We are not done that. We are not who was there, who was not there. Mr. Thus, I'm not here to find out what he wants. I'm not here. What I mean to say is his projection is different. The projection made by the petitioner in that and the respondents in that case is different. What is material for me is what this court finally held. This court finally held that instructor is a post inclusive within the post of senior instructor and also includes instructor mathematics, social and English. You have not filed an appeal here. So this has attained final.
in this case.
Why?
Because madam, at that point of and for mathematics, madam, their qualification.
Oh, here the post is one thing. Are they instructor English and social studies?
Yes, madam, now.
Just for a moment, your argument in the earlier round of litigation, para 15.
15.
Para 15. When so learned counsel appearing for the labor and employment has opposed to the submission made by Mr. Datta, learned counsel. According to the counter filed by Rasmai, he submits that the gradation list of senior instructor and junior instructors were prepared cadre-wise as per provisions. He submits that the post of instructor mathematics or instructor social studies or instructor English language do not belong to the cadre of senior instructor. They themselves, as your lordship, brought in these groups, your lordship. Same argument. Consequently, there is no provision for their promotion to the next so and so. Same argument, your lordship. Aspect of that.
And even says that earlier it was done, the High Court had rejected.
Sure.
Yes, I forgot that. I've seen it. So your this argument is what you're making today. That is answered in para 22.
Here, my lord. Qualification is, that is not mentioned here, my lord.
I can't go beyond that. This is an interpretation of the rule. That means it's an interpretation of everything that comes within the purview of that rule. So if that be so, we'll have to allow this writ petition. So what is your claim here, Mr.?
We are seeking promotion, your lordship.
To the cadre of supervisor.
And in fact, your
Now,
lordship,
in after this rule, this order was of
2012, your lordship.
when were you recruited? 2014.
2014.
When were you recruited?
Your lordship, we were recruited, your lordship, two of the petitioner number 1 in 97, petitioner number 2, 1993, petitioner number 3, 2010, and petitioner number 4, 2010.
So after this rule, there was a direction that a gradation list of all the incumbents in senior instructor. Now, in terms of this decision, maths, social, English, everybody was a combined seniority list prepared. Why?
It's only in respect of mathematics.
The others, you did not object to that.
That, your lordship, we have filed representation, that your lordship,
Okay, you came before this court only in 24. How do you explain this 10 years delay?
lordship, when we were told, your lordship, that since this judgment does not cover us, your lordship, since we are not party to that, your lordship, therefore, your lordship, apart from your lordship submitting representation,
Where is your representation? First representation you have
first,
submitted.
your lordship will get it at one, your lordship will get it at page 55, your lordship. And that's why, your lordship, we are not seeking it retrospectively, your lordship.
You want it from
Yes,
today.
sir. Not seeking it retrospectively, your lordship. No delay will come if we.
So you
seek it-
appeared only in 23.
Lordship. Earlier representations are also there, your lordship, but I have.
And whether you are still in service.
Yes, sir. We are still in service, and the one of the petitioner is going, your lordship, even after around 32 years of service, without any promotion, your lordship, he served, your lordship. Then that way also, your lordship, we are entitled to, your lordship.
Protol Kumar Das would retire after 2 years. And the others?
Others, your lordship, one has, other two, your lordship, 3 and 4, your lordship, have some time, your lordship.
3 and 4 has some time. 1 and 2 will retire soon. Yes, Mr. After that decision, which has attained finally, and para 22, that conclusion, that they are also included. Why should this court go and explore the matter beyond that? Whether it is permissive. Your submission in para 15 is already same thing.
And my lord, that my lord, the rule that judgment was passed. Rule 314, my lord, wherein of social studies over.
Okay, now just show me. Okay, we'll explore your thing. We'll explore your thing.
Of that, my lord, we have paid them ACPS, my lord.
That is normal. That ACPS, otherwise also everybody will get. What is the guarantee that they will get promotion as supervisor? Because there would be a very limited number of posts as supervisor. And the feeder cadre now being there, it's a big feeder cadre. Now, tell me, where is the method of promotion to supervisor, Mr. Bhattakur?
Lordship, that is your lord. 7, your lordship. Well, rule 13, your lordship.
No, rule 11.
12. Starts from 12, your lordship, from senior 12, 1, Romans 5, your lordship. From
Roman 12, Roman 5.
Roman 6, your from
Roman
senior
6.
inspector.
Okay.
Then 13 is the general procedure of promotion, your lordship.
That is different. How many posts are there in the cadre of a supervisor? Any breakup of the posts given here somewhere?
Not your lordship, that is.
Now, Mr. Bhattakur, one question.
Yes.
Admittedly, you are not senior instructor till now. You are only instructor. It's by virtue of that finding of this code that instructor also, senior instructor also includes instructor, you come in. Why did you not file an appeal? But it will be prospective.
That will perspective. I have also not made any prayer for that.
Prospective. Mr. Das, I'm sorry. It's your endeavor that is going to. Unfortunately, this argument of yours should have been made before the appellate court by filing an appeal. Maybe we might have had some other result.
Submission is there, my lord. There is an
You give me your submissions in writing by tomorrow morning. Tomorrow. Night. 3 o'clock only. 3 o'clock only. Just write down 1, 2, 3, 4, whatever your submissions are. We'll pass the order on Thursday because today we'll have to rise now. References. You are also there. We go. Putting. Third deal and counsel for the parties at length. The hearing remains inconclusive. Registry to list this matter again on 14/11/2025. I'm not writing. You just give it to her tomorrow, day after, whenever it's possible. But day after you'll have to. Your submissions. So we'll only hold that this court will quote those judgments that this court having included the post of instructor to be forming a part difficult, but can't help it.
Ultimately, Your Lordship, that is.
Yesterday night I was finding it difficult to appreciate, but once that law is laid down, we can't. And the justifications are there in the judgment, why it was done. You have your little